Morning, one and all. Civic and Politics Cell welcome each one of you all. Today's session is organized in the Bible. If you heard the word of God today, it's not my will, but by thy. So today's session is all about your will to be done. Okay, now I call our Civic Cell head, Advocate John DeCosta, sorry. Please join the panel. Also, I request Father Thomas to join us. Okay. A round of applause to all of them. Now we welcome our chief guest, Advocate Rajiv Jadhav, to join us, please. We also request John to join in for a question and answer session. Requesting Teresa to welcome our chief guest. Okay, round of applause to all of them. Okay, a few important points before we start the session. We will be circulating certain paper and pen. To write any question, please raise your hand, write it on the piece of paper. Our volunteers will come and take your questions. There is drinking water kept towards my left hand side. You can use the glass, the disposable glasses are kept there. Anything else? So let's start the session now.
Good morning, everyone. Little brief introduction of our chief guest and the main speaker today, Advocate Rajiv Jadhav. He practices exclusively in the testamentary section of the Bombay High Court for the last 15 years. Exclusive practice. All your doubts earlier used to come for legal cell and all regarding will, LOA, succession, everything, annexed will, registered will, everything, you can get all your answers direct from the horse's mouth. So I'll be open to, now the session will be open to Advocate Rajiv Jadhav. Please come.
Bus? Can I start? Thanks to all of you, my esteemed audience, for attending my session with respect to the will and succession and nomination. It's my request that I will ask some question to you. If you can answer, that will be better understand me that what are your queries about the will. And you consider me as your part only. So don't consider me as an advocate. I am part of your group only. Can I ask you one question? Do you have any idea about what is a will? What is a succession? Is anybody having any idea? No? Can you please ask?
It's a written document.
Yes.
Giving my intention.
Yes.
Of giving my possession.
Yes.
To people I would want to do.
Yes.
And it would have two witnesses.
Yes.
To endorse that is the document.
Yes.
You can use it to work. You can remove. You can be free, sir. No problem.
Okay.
Yeah, you can sit.
It's a legal declaration of a person who intend to dispose of his or her property after his lifetime in respect of his property. The will is codified in Indian Succession Act. There has to be at least two witnesses to the will. Therefore, witnesses must be there. You can appoint a person to execute the will who is called as an executor. After the demise of the person who is called as a testator, the role of executor will come into play. Executor is a person who has to act as per the wishes of the deceased, that is testator, to get the probate from the court, to administer the estate, and after the obtaining probate, he has to administer the property as per probate. So will is a document wherein the person is called as a testator. The person to whom property is given is called beneficiaries, and the person who appointed to execute the will is called as an executor. Now will is most important document. Why should make a will? Is anybody having any idea what is a will and why one should make a will? Do you have any query? Will, someone is to make a will so that his hard-earned money, his hard-earned property is to be bequeathed or to be given after his demise to his beloved ones, to whom he wants to give. Therefore, will is most important thing. Someone is to make a will. After that, the will come into effect after the demise of that person who is called as a testator. After, there is no age bar wherein will is to be made. A person who is above 18 is major and who is of sound mind, he can make a will. Now, who cannot make a will? The person who is minor and who is of unsound mind, he cannot make a will. Also, the most important thing, two attesting witnesses are required, at least two. If it can more, no issue, but at least two attesting witnesses are required. If it is possible, doctor's certificate is also required. Registration is not compulsory, but if it is registered, then the will get weightage, that the testator, the person who makes a will, who personally goes to the registrar's office, who makes a will, who sign in front of registrar, and this biometric and all that, so that carries the weightage when someone goes to a high court for probate. Therefore, registration, if it is possible, registration can be done, but it is not compulsory. Will also cannot be stamped. Will is not required to be done on the stamp paper. Plain paper can also be do. The person who makes a will, he can write a will on his own handwriting, and two attesting witness is to sign in front of him. That is the whole process. Now people, why the people cannot make a will? Because they are under impression that if I am married, then definitely my whole property goes to my spouse. But this is wrong impression. This is not correct, because after the demise of a person, the will after demise of a person, if a person died without making a will, then definitely if a male person died, then his mother, his son and spouse will come into effect, come as a legal heirs. They are the beneficiaries first. Therefore, will is required to be done. Many people, they are saying that no, nomination is done, therefore will is not required. As far as nomination is concerned, the nominee is like a trustee. In many judgment of the High Court and Supreme Court, it has been upheld that nomination he is like a trustee. He is not the owner, and his duty is to distribute the property amongst all legal heirs. Therefore, if a person makes a will, he can bequeath his property after his demise to whom he wants to give. If someone makes a will and after some time, suppose if he find some correction is to be done, he bought some property and he want to incorporate in the will, then he has to write one codicil, which is called as a codicil, which means the amendment to the original will. But same also, if you can register, that will be better. The latest is the considered valid in the eyes of law. So by way of a codicil, you can add the additional assets which you bought. If your intention also change, if you want to give a X and if you do not wish to give him, then by way of a codicil, you can amend your will through codicil. And same also is to be attested by 2 witnesses. So at the time of once will is made, many people are under wrong impression that once will is made, then automatically all the property will be transferred in the name of legal heir or to whomsoever he has given. But it's not. After getting a will, after registration, probate is required. In some of the states, probate is not required. Merely on the production of a will attested copy, in some states authority transfer the property, but in some states probate is required. Therefore, probate, we have to get the probate done once will is executed. That is the thing. Probate is a certified copy of a will along with the administration of estate issued by the High Court. Probate we can file in the High Court or we can file in the district court of the respective district. But if a person died in Mumbai, then we will have to go to High Court for the probate. Probate is compulsory, yes. Probate is compulsory. Yes, madam. Probate. Yes. Yes.
हां आता कसं आहे हे इंटरॅक्शन आहे ना त्यामुळे ते बरं पडेल कारण मी एकटा बोलत आहे
Yes, madam. Yes.
Just to reiterate my point, we would like to know what is the procedure, what are the documents required for probate
Yes.
or acquisition of a probate?
Yes. Can I answer? After person died, then the executor, if appointed in the will, he has to make an application. Or if executor is not there, then legatee means the beneficiary under the will, they have to make an application. Suppose if executor is there, executor is named in the will, then the executor is to file petition for probate to the High Court. And for that petition to the probate, death certificate of the deceased is required. Name, address, and name, age, address of legal heirs are required. Details of property the deceased hold, that also required. And most importantly, the attesting witness, whose affidavit is required, because after demise of a person, everything is depend upon attesting witness. Attesting witness is to file an affidavit in the court stating that at the time of execution of the will, I, along with other attesting witness and deceased, were present, and we had seen that deceased had signed, we all signed, and he was of sound mind. But consent of all legal heirs are must. Suppose even after registration of a will, if one legal heir is not consenting, then definitely he will file caveat, and that matter will drag for at least 15 to 20 years. Therefore, for probate, even after making a will, consent of all legal heirs is must. Yes, madam. Family, if someone makes a fake will, then definitely they have to go to the court for filing probate. They will have to take probate from the court, because without obtaining probate, no authorities in Mumbai can act on the basis of mere production of a will. So once the probate is filed in the court, then definitely the citation will be issued to the non-consenting legal heirs, first class legal heirs. So once the first class legal heir receive citation, within 15 days of receipt of citation, you will have to file caveat, and then matter will be converted into a suit. If a person died intestate, means there is no will, then definitely, if there is no will, then the respective rules, regulation will come into effect. For Christian and Parsis, Indian Succession Act will come into effect. Therefore, after demise of a male person, then his legal heir, means his mother, his widow and sons, children, they will be the legal heir. So if a person died intestate, then the property will be distributed amongst his legal heirs. And if a person makes a will, then as per wills, the property will be distributed. Yes, madam.
I just had a question. You know, if we are making a will in normal circumstances, the will, so I'm making a will and I decide how I want to distribute my own property. I can't decide for anyone else's property,
100%.
but my own property.
Yes.
And for some reason, if I want to give certain, of my legal heirs, so I may have, my legal heirs would be my children, right? And my spouse.
Yes.
So that's clear in law.
Yes.
And so if I understand, I want to divide my property in such a way that to someone I may give a certain proportion and to someone I may give a different proportion.
Yes.
And so that's my decision, that's my will, I have registered it. But I didn't understand this point about we need the consent of the heirs
Yes.
to probate this will. Because it's mine, so why should anyone give their consent to probate or not probate? I mean, this is something new that has come up, and I'm asking you this because I work in the social field, and I come across many cases like this, and there's so much confusion on, because even probate was not necessarily earlier. But now probate has become, compulsory in the Mumbai district. And secondly, probate is an expensive business. There is a high cost, right? There's a
No,
fee
sir.
that has to be paid.
You complete your question, then I will
So
answer.
this whole question about probate, the expenses involved in probating a will, one,
Yes.
and this whole thing of getting the consent of heirs to this will. These are two things I seek
Yes, I
clarification.
understood your question.
Thank you.
If my mother is residing with me and somehow due to coercion, I took her to registrar's office, I told her to sign this will without her wish, and I am showing this will as a genuine, and my others, brother and sister, they know her intention is to distribute, because parents, they are having equal love and affection towards their children. So sometimes if I tells my brother and sister, no, she made a will and everything goes to me only, will they believe it? Because she was residing with me, I put coercion, undue influence, misrepresentation, and I obtained the will. I got the somehow registered the will before the register office. Then can my brother and sister accept this as a genuine will? I may have misrepresented her. I may have put some coercion, undue influence on her. To avoid this suspicious, the court want the consent of all legal heir. But in many cases, in spite of following due process, in spite of out of own volition of the deceased testator, others are filing caveat, and matter is dragging for at least 15 to 20 years. You got my answer? Now your question, second question about the cost. Yes. The valuation of the property above 12,50,000. Maximum court fees is 75,000 we will have to pay. Even you have 100 crore property, 75,000 is the maximum court fees you need to pay. And advocate charges varies from advocate to advocate. So that I cannot comment on that. But as far as court fees is concerned, 75,000 you need to pay. And that process may take at least 12 to 15 years. That I must tell you. No, madam. Earlier we used to get probate 3 months, 4 months. But right now because of some procedural changes, it is taking 12 months to 15 months. Yes. Maximum, yes. Yes.
If nobody is contesting the probate.
I told you, even if nobody contested, 12 months to 15 months.
Okay. Thank you.
There are a lot of questions you need to answer from you. You write it down, na? I would request everybody to write your questions in a piece of paper so I can just forward it to you. Otherwise, it will be only one person talking and others won't get a chance. So it's a request that I'm passing some papers. You can just write your questions and we'll answer your questions. Okay.
Excuse me, sir.
Huh.
I have a juxtapox situation.
Yes.
It's like this. Ours is a very big family, and we are very, very amiably settled all the landmarks which belongs to whom, because there were a couple of 5 brothers. Now, what has happened is the children down the line don't know what their fathers or ancestors have done. And unfortunately, nothing was registered by our ancestors and fathers. So if my brother or my brother-in-law or whosoever wants to give it to XYZ and it has not been registered on his name, what's the point of that property? Does it stand legal or illegal? That's it.
The property stands in the name of whose name
The ancestors, the grandfathers, whatever, which was never divided among the children at that point of.
Then first of all, you need to transfer the property. You have to you have to incorporate the name of legal heirs of the ancestor. Then their share will be ascertained, and once the names are transferred in the property, then only they are the owners, and they can transfer that property. They can make a will to that effect.
Half of them have already expired. So what's
Then their legal heir will come.
Okay.
Means before, see, actually in the will, no, whatever you have, that only you can give to
Divide.
others.
Okay.
I cannot give the property which belongs to my friend.
Because now what is happening, the other families are saying this is a family house or this is a family property. And they just enter
See,
in, you know.
actually, as per family chart, family tree, you need to ascertain share of your ancestor.
Okay.
You have to pursue that process.
Okay.
And after that, you have to incorporate your name as a legal heir of your ancestor. And then you can do this thing. But first of all, you need to ascertain your share in the property. Then you can do. Yes. Because once your name comes into the this legal heir list, no, then definitely you are that share is ascertained in the property. Yes.
Okay, we go for the next question. There are a lot of. One moment.
I hope you're all getting the point. Will, why it should be made? What is will? Why it has to be made? If will is made, is not made, what are the advantages of the will? Which is registered, non-registered. Without will also property can be distributed as per the personal laws of the people. So that context, if you have any questions, ask now. Otherwise, we'll deal with the question answers later on. Will is the intention of a person who wants to give his property. Suppose I have a couple of assets with me, immovable, movable. I will decide whom it has to go after my demise. That is a will in plain paper, without any stamp paper, nothing. It's a plain writing. Even my handwriting also will do in that, with the two witnesses. So now what happens is, when I am no more, that two witnesses will say that yes, it is signed before us. And one, there will be executor, one who carries forward the will, how it has to be executed. Got my point? So thereafter, what happens is, just merely having a will, it will not give you the license to own the property and sell the property. Somebody has to at least say this will is proper. It is a proper document. Who is the authority to say? The competent court. The competent court is High Court, where Rajiv is exclusively doing practice for 15 years. He is the right person to tell you the nitty-gritties, technicalities of the will in execution of the will till the final disposal by the donee, by the receiver. Now, without will, with will. Now, there is a will. Now, just having a will, it has to be probated. What is probate? Probating a will means it is a one step further, the execution of the will. How it has to be transferred. That is called probate. Anything on this? Yeah. Yes, I'll tell you. Now, Rajiv will explain to you all everything about it. I want to make it a final, what is it? The subject is why to have a will, with will, without will, how the property will devolve after when the person is no more. That is how, that's what this civic cell has called this conference or seminar, exclusively deal with that. Every one of us have some of the other properties, movable, immovable. How it will, after you, what will happen? Will is one-step protection. A person dies without a will. Still, the property will not go to anyone. It will go as per the Succession Act, as per the law of the person. For us, it is Indian Succession Act 1925. Others, there is a different laws. So now, with will, there is one-step protection. Registered will, the second way of protection, because for registering a will, one has to go to the registrar's office. He has to give his biometric. So the court says this person has gone to the court with the witnesses. So that's a second layer of protection. Without registration, someone does a will, it can so happen person is in ICU, somebody forges signature, somebody witnesses, someone is the executor, because executor signature is not required, only witness signature required. So therefore, registering a will has one second layer of protection. Ultimately, the competent court only will decide. Now, in a housing society, some flat is given to someone by way of will. The one person is no more. Society will do as per the nomination. But to sell that flat by the nominee, you require this particular probating the will. And once you probate the will, court will issue a certificate that is called LOA, letter of administration, heirship certificate, section certificate. There are various ways. The technicalities he will tell you. This is how it is. This is a basic how it is, how it works. Yes.
Huh. What is I'm reading the question. What is a gift deed? Can a gift deed be contested? If father has made a gift deed favoring only one child, can other children contest? No. Because gift deed, the father has gifted out the property during his lifetime, and on the basis of gift deed, the society has transferred that property in the name of a child. Therefore, you cannot contest the gift. Yeah. I am reading a question. Does executor have to be a third party mandatorily, or can beneficiary as a legal heir be an executor? Executor in the will, if a person makes a will, he should endeavor that the executor is to be appointed. That person should be with utmost integrity. He should be your well-wisher. He should be your friend. He should be a beneficiary. No issue on that. Beneficiary can be an executor. Beneficiary can be executor, but executor cannot be an attesting witness. Beneficiary cannot be an attesting witness, because everything is depend upon the attesting witness. Therefore, executor can be beneficiary third party, but that person should be trustworthy, and he should act after the demise of a person to get the probate done. I am reading question. If divorcee and a child is minor, whom will the will go, and if no will is made? I don't understand this question. If divorcee and a child is a minor, whom will the will go if no will is made? I do not get this question.
See, if we basically start saying if there is a divorce, we have to take the next.
Let him ask.
Hello. So if like I'm a divorcee, so I have a minor son. So if anything happens to me and I've not made a will, so in that case, who the property will go? Like my property.
Definitely your son only. Legal.
But he's a minor, so still it will go to him.
Yes, 100%.
Okay. Yeah.
But only question is that it will go to him only. So someone has to file a guardian petition in the court.
Okay.
And after appointment of guardian, he can apply for letters of administration with respect to the property.
So any family member of mine can do that.
Your closer one family,
Okay.
they can apply for the guardian petition. Yes. Your brother, your sister.
Okay.
Yes.
Thank you.
Thank you. Can you just read this?
Can you bequeath your will to your brother and sister? I have no children, so do you have to come to India to give the to write the will?
Is she married?
Can you bequeath your will to your brother and sister? I have no kids, so you have to come to India to bequeath.
She
No,
must
it's
be
not
married,
mentioned. So let's take the vote condition, no? Yeah, definitely married. Yeah. Let's take the condition where the person is married and not married, but she has property. So who can she give it to, her brother and sister? That's the question.
I'm reading a question. Can you bequest you a will
To the brother and
to brother and sister? I have no kids. Do you have
do I
and
have to come to India?
do I have to come to India? You can make a will, but if you are married, then your legal heir will be your husband side. And when husband side legal heirs are not there, then only this brother and sister will come into picture. As far as married women are concerned, so she can come to India and she can make a will, but definitely citation will be served upon the husband side if they are alive.
She wants to give her own property which she has made.
But still,
Still, huh?
still, yes, she can gift it out.
This is a multiple question.
Ah,
So this is also been answered.
ah.
Can we witness the children beyond? I'll take this question. So this question will be, what's the cost of probation?
With the will and with the will and without will also. Yes, both.
Can a bishop, no, can brothers also answer?
Huh? Actually, see, if a married woman died without a will, then her brother and sister cannot make an application. If she is unmarried, then they can make an application. Suppose if she married, then if she leaves a will and give it to brother and sister, then definitely citation will be given to husband side relative. Huh. Can a beneficiary to be an executor? Yes. Does state of Goa requires a probate? See, actually, some of the state, they on the merely on the production of will, they transfer the property. Some of the state, they are not. Right now, due to valuation of the property, many authorities, they ask that you go to court and obtain the probate, letters of administration, succession or heirship. So that I will have to check whether state of Goa requires the probate or not. Third question, can husband and wife make a joint will? Yes. Husband and wife can make a joint will, but that with respect to joint property only. Joint properties. If one property stands singly, then they have to make separate petition for that single property. If you are making a joint will, then ensure that all properties are joint only. So in that one petition only, they can file for probate. How do you prove a person is of sound mind? What if a doctor's certificate certifies the person is okay, even though not? See, actually, this question is question of evidence, cross examination. So that the party, those who are claiming that the person is not sound mind, then doctor has to be cross. Doctor is to step into witness box. So this process we have to follow in the court. हे काय? Advantage of a will.
Will versus gift.
हाँ सर. हाँ. प्रोबेट पाहिजे. हाँ.
Advantage of gift deed versus
Gift deed, the advantage of a will and gift deed. Advantage of gift deed is that we can gift out the property during lifetime. So there is no chances of any dispute, because during the lifetime of the person who is gifting out his property, and on the basis of that gift deed, the property transferred in the name of the donee. But for gift deed, you have to pay 1% register stamp duty charges and registration charges. Ready reckoner valuation of the property. Ready reckoner. No, no, no. It has to be registered. Gift deed is to be registered. Merely notarial register gift deed won't accept. See, actually, if you buy a flat number 1, then his title, his agreement is different, right? Flat number 2 agreement is different. So each and every uh, gift deed is to be different. Yes, not you can do it in the single gift deed. Yes, yes, because see, actually every property has a title. Therefore, it has to be different only. One question is remains, no? No. हाँ. That we have already answered, no?
Is it necessary to inform heirs that a will is done?
I am coming to the topic of succession. Succession is a process by which the property of dead person has been transferred to alive person. Succession is a process. The person who died without a will is saying he died intestate. And the person who makes a will, we can say that he died tested. Therefore, succession is a process. Succession has two things. One is a will and second is a trust. Will is a simple thing. As far as trust is concerned, then we will have to, trust is a important document and it's more mechanized, customized thing through which property can be transferred for the benefit of the beneficiaries. But right now I am talking about succession and wills only. Will is, if you make a will, then the person who work hard through his life and he earn property, then definitely he has wish, definitely he has right to decide to whom he should give, when should give, and the proportion. For that clarity is required. Therefore, in the will, the clarity is required, and through will you can give your property to whomsoever you want. Charity purpose also you can give. Likewise, if a person died intestate, then the property will goes to legal heir only. He cannot do some charity work if he wishes to do. Also, in the will, all the properties are to be incorporated. Residuary clause is required and it is to be meticulously drafted. That is the thing. It differs. There is a template you can do, but at the same time, customized thing. We want this should go to him, so it has to done to professional person only. I will advise. As far as nomination is concerned, nominee is like a trustee. So on the basis of nomination, property cannot be transferred. They will ask for succession heirship from the court. Yes.
Rajiv, to summarize now, I'll take a similar question on their behalf.
हाँ.
Now, first is, what is will?
हाँ. Will is a legal declaration of a person of his intention in respect of his property to be carried after the demise of a person. Will is the only document which I have seen that will come into effect after the demise of a person. And the person who makes a will, first of all, there is a declaration. Declaration is a legal declaration. Now, who can give legal declaration? The person who is of sound mind, the person who is major, who can make a will, and the person who is unsound mind, he cannot make a will. Why will should be made? Because in the will we can give the property. Huh.
Got it. Got it. Now, what is after the will is made?
Huh.
How it will go to the final destination? How it will reach to the final beneficiary, final recipient? That is about LOA, heirship, those things.
Huh. If a person died testate, means if he left a will, then definitely probate is to be filed. Probate petition is to be filed. And after getting probate from the court, probate is a certified copy of the estate of the certified copy of the will attested by the court of the administration of the estate is called probate. If a person died intestate without a will, then letters of administration to be filed. The letters of administration who will file? The letters of administration is filed by immediate legal heir, means first class legal heir, they have to file. And heirship, normally if a person working in a factory or a company and if he died, then there are 2-3 legal heirs. Nowadays for everything they are quarreling with each other. So the company will say, you go to court and obtain heirship certificate. For obtaining heirship certificate for service and job, we will have to pay 200 rupees court fees. And succession, as far as succession certificate is concerned, the immovable property like shares, amount lying in the bank, for that we need to have succession certificate.
That is movable.
Yes. Gold, yes, but we can transfer that gold during lifetime also.
Now, Rajiv, on the basis of will, whether registered or not registered, siblings, the relatives of the deceased give NOC consent to the concerned people to transfer the flat. Can it be transferred without probating the will?
No, probate is required. Probate is required because whenever they want to sell it off in future, then title is not clear unless and until probate is obtained from the court or letters of administration is obtained from the court.
Okay.
First of all, suppose executor died before the person, then definitely he has to make separate will. Yes, he has to make a separate will, and as far as attesting witness and executors are concerned, the person who makes a will, they should choose a person who are quite young, quite healthier, so that he should not, the attesting witness.
And a will can be made n number of times. Only you have to add a clause in the will that
No, we can make a will subsequently.
Yes.
Yes. Also, for any correction, we can make a codicil.
If that is not possible, if the person dies and he doesn't know his witnesses have already died and the executor is not available, then what happens to the will?
Then in that case, the legal team is beneficiary to whom this property they are getting. They have to file letters of administration with will annex to the High Court. Also, at that point of time, they will have to check whether at the time of execution of the will, apart from two witnesses, are there any third person was there or not. So his affidavit is required.
Hello. Just want to, yeah. In case of a single child, if there is, hello.
I
Yeah,
hear.
I just want to know, in case of a single child, when both the parents leave a will in the name of the child, is it still necessary to be probated? And secondly, if can the child dispose of the assets without any probate?
See, actually, nowadays we are doing due diligence. Suppose if someone wants to buy a flat, then definitely he will come to us and he will say, I wishes to buy a flat, which approximately in Mumbai definitely above 1 crore. Then definitely we will suggest him that you have to do due diligence, like public notice. We have to give public notice in two newspapers. Also, search report from the registrar's office. The transfer happens since last 30 years. So, advocate only will suggest that letters of administration or probate is required because we don't know the legal age of the person, deceased person, and one person is coming and claiming to be his son and claiming that I am the only child. I personally don't know. Therefore, it is always advisable that due diligence is to be done while buying the property, and also these probate letters of administration we should obtain it even though we know that he is the only child. To protect our interest, we have to do all this process. Huh.
Excuse me. Hello. He's asking.
Okay, there's one question here.
Has the witness to be a family member or any other person also?
Basically, as far as possible, the witness should not have any conflict of interest. Huh. He can give 50%. I am reading a question. If property is jointly owned and mother dies, so I believe that mother and father are jointly own the property, dies without a will, can father,
Can the father give it to one child?
he can give to one child his 50% right, title and interest in respect of the property. As far as 50% is concerned, so he has to go for letters of administration. If a person died intestate, same way the way probate we are filing, we will have to file petition for letters of administration if a person died intestate. In the letters of administration, we are saying he died intestate. Therefore, we are filing petition for letters of administration. And suppose if he died testate, then we will have to file probate petition.
Okay, there's one more question.
Yes, yes, yes.
75,000 only. See, actually, succession, letters of administration, probate, and heirship, if you are claiming no, then maximum 75,000 court fee is to be paid. 75,000 is maximum. Huh? Yes.
Okay, there's a question here. One moment, ma'am, one minute. Let's go.
Yes, yes, ask.
Let's all
Yeah.
not speak together and it won't be answered.
Sir, see, a will was made and registered when both the parties were there, were alive. Okay? Wherein it's mentioned that so and so estate will go to one person and one child, and the other estate will go to another child, and the remaining assets would go equally to both the children, 50% each. In that case, is there necessary to make a probate, or the will can be executed by the brother or sisters of the either spouse? And it was written that when either spouse dies, like when husband dies, the wife will get, and when the wife dies, then only both the estates will be equally divided, means maybe more or less one estate for somebody, the other estate for someone, plus the assets will go equally to both the children only after the death of the second spouse. First spouse has already died, so second spouse. Now, in that case, if the brother or sister of this alive spouse, can he execute it without the probate? And if there is a probate, what will be the charges more or less, and what are the procedures of that probate, to do the probate?
Property stand in whose name the property is standing?
That's a very important question. See if you can address this. Very important.
Property is joint with both, and when both the parties were alive, the will was done and registered. So now, after the death of the second spouse, then only it is mentioned that it will be given equally to both the children, assets. And the estate to separate person, his name, and the separate person, another estate
If
to
the
another.
property is joint and if the will is joint,
It is a joint will. It is a joint will.
then joint probate petition can be filed.
It is like this: if A predecesses the B, vice versa, and
Yes.
thereafter the second, thereafter property distributed as per the will. Then
Yes.
Now, few questions here. What if a witness dies?
If a witness dies, then definitely we will have to prove that apart from, if two witnesses are there, so we can file affidavit of one witness, that will suffice.
That will be added to the
Yes.
original will. Second, what if the entire family dies in an accident?
Sorry.
What if the entire family dies in an accident?
Then definitely as per legal heirs,
Succession laws. It will go as per the personal laws of the person who died.
Yes,
Correct?
yes,
Acha.
yes.
Third, is video recording important while preparing the will? Which is no.
no, not required.
Can a person both make a will and a gift deed? Can the legal heir claim it?
Actually, will come into effect after the demise of the person. Gift deed, he can gift it out, then there is no value for the will.
Yeah. So gift deed is like this, as if you were agreement for sale. Within the family, blood relation, you can gift a deed, gift your flat, whatever.
Third party also we can
Yes,
give,
and
only it may attract
Stamp duty at the
registration.
concessional rate, registration, as if you are selling a flat to the
Yes,
person.
it's like convention.
It is advisable to do a gift deed if you are so sure that your siblings will take care of you in your lifetime. When you do the gift
Yes.
deed, that is full and final, misuse of this machinery later on among the siblings.
I must tell you one example. The Raymond who transferred, gifted out whole his asset to his son, and now the Raymond's Singanias are on the road. Therefore, it is always advisable that you should have control over your asset till the last breath.
Yes, correct. Now here the will is after your death. Gift deed when you are alive, you are
Yes.
transferring the assets once and for all.
So there are chances are less of dispute.
If the children are other citizens of any other country, still they have legal rights to properties in India. It is yes.
Yes.
It is yes. If a gift deed has been made of a flat, does not have to be executed immediately, or flat is transferred after the death. No, gift deed has to be executed moment it is done. It is as good as a sale,
Conveyance, yes.
as good as a conveyance, transfer of
Yes.
property. A person has made a will and kept it in the will in the with the witness. After a year, the person who made the will expired, but the witness who had the will had misplaced it or lost it. What can be done?
Can you just?
One who had made the will,
Ah.
kept with the witness, the person died, the witness also dies. So what happens to that will?
Then can we find a will?
No, he cannot find the will.
Then everything is
Then
gone.
everything is gone.
Then letters of administration.
Yeah. If a widow makes a will, in the citation sent to the husband's family, if a widow makes a will, whether the citation
Yes.
we send to the husband's family,
Yes.
it's a public notice, 30 days newspaper notice,
No, no, citation is to be served through court only.
court only. Yes. How long does the succession takes if a landowner dies intestate? That is about 1 year, 6 months to 1 year. Can a will be challenged? Yes. Whether registered or not registered, will can be challenged. What are the fees for the probate along with the legal fees? That you can consult fees for the court fees. Rest lawyer's fees is up to the lawyer, one who charges it. Once you get the succession certificate, heirship or LOA or probate, you are legal owner. You will be able to dispose of the property as per your will. You can sell the property to a third party, etc.
Yes.
That's what I summarized here. What you have, anything more, you can. If a person is single, does she or he has to create a will and transfer the property only to blood relations? If given to anyone else, can the family contest the will?
Yes.
Yes, of course, yes.
Yes.
Yes, because is as per the personal laws of the person who dies intestate. But if
She makes a will, no?
if she does not make a will, if
Then
she makes a will
definitely-
and gives a third party, but still her relatives can contest the will.
Yes.
Because she falls in the definition of family.
Yes.
Correct? The best way for such person is to transfer the property during her or his lifetime.
Yes.
Agreement for sale and transfer it.
But provided they should take care of the person.
Yeah, that is there. Nowadays nobody transfers that way. Nobody. Everything they keep it for themselves.
Can I read
Yeah,
this?
yeah. And I wouldn't advise also. Now you take. Yeah, we'll take up. Because at 1 o'clock we have to wind up. 1 o'clock. The hall is till 1 o'clock.
Can I read one question?
Yes, yes.
Our house was in my son's and my husband's name. Now my husband passed away. He has made a will in my favor. He has also nominated me for the flat. Now the society says you cannot nominate anyone because it's not registered in your name. But in society they have added my name. How is that without nomination? The flat is standing in the name of your husband and sons, and he has made a will. Therefore, to extent of his share, he has bequeathed the share in his flat in your name. For that, you need to obtain a probate, and after probate, the society can transfer in your name. Nomination is concerned, that is okay, but it should transfer as a legatee. And after getting your name in the share certificate, you can nominate. if a if there is a consent from all legal heirs, still we have to probate the document. Yes, you have to probate the will. Once document is probated, how the document is registered and if the property is to be sold. After getting the probate from the court, if the property is a land, then definitely you will have to go to registrar's office, collector's office, get your name in the property card, and then you can sell it off. As far as flat is concerned, this, on the basis of some procedural completion of procedural aspect, society can transfer your name. Probate can be done when a person is alive. No, because will come into effect after the demise of that person. What is advocate fees for probate document? Huh. What is release deed, and it is helpful for transferring the property. Release deed means he is releasing his right in the property. To certain extent, yes, it's helpful. Yeah. If the will is registered and is done as per person making it, then what in the role of a witness? Even after registration of a will, probate is required, and witness after demise, witness is to file an affidavit stating that I was there and the testator means the person who made a will, he was of sound mind. In the will of the father, yes,
So the question is, if the father gives the property, wills the property to the wife, can the children contest?
yes, children can contest.
Okay, the next question is, if ancestral property is given to A and A has given it to one child in his will, can the second child contest it?
Yes, no, ancestral property.
Ancestral property is given to only one child, can the other child contest it?
Ancestral property, to the extent of the person who is having share, he can will that share only
Yeah,
in the will.
correct. But the problem is,
Yes,
over
yes.
here is, they say as per the Succession Act, both the children have equal right on the father's ancestral property, not the father's property which is being bought only by the father,
Yes.
but ancestral which he inherited. So the question over here is, can one child contest
Yes,
the
he can
will of a
contest.
father who's given ancestral property to only one child?
He can contest, yes.
Can contest. There is a dispute of one child with the parents and brothers and sisters. Can the parents make a will and register it and give that no property will be given to the other child, okay, on the demise of the father? And can the child who is affected by this particular will contest it?
Yes,
Can be
he will contest. Contest means
challenging the
challenging the will. They will file a caveat. They will file caveat. Caveat means they are disputing whatever stated in the petition. They are saying will is forged, fabricated, and on the basis of that, the testamentary petition will be converted into a suit, and that suit may take 50 to 20 years.
That is why it takes 15 to 20 years.
Yes.
If it is contested, then okay, if a person is single, does he or she can write a will to transfer the property to a blood relation, or can he give it to anybody?
He can.
If a person is single, it's not there. This is the question. If a person is single, does he or she have a will to transfer the property only to a blood relation? Is it mandated, or can he give it to anybody? That's the question.
He can give it to anyone through will. Yes. Yes.
Okay. What if a person is unmarried and does not want to give his property to that's the same question. Okay, asked.
Yes.
Family members can contest. Okay, is it true that a Catholic and a Muslim are not required to probate the will?
No.
Yeah. Okay, the question is it true that a Catholic or a Muslim do not have to probate the will?
As far as Catholics are concerned, they have to probate the will. Muslim got different law. As per Muslim law, a Muslim person can bequeath only 30%. But for Catholic, probate is must.
We've received a question, can a beneficiary take the executor to court for not executing the gift by the testator? The question is totally wrong. So if you need any, if you want to reframe that question, kindly put it forth to us so that we will answer it. Because there is no question of a testator when a gift deed means it's already transferred during the lifetime of the person who is executing the gift. Okay, now the next question is, if both parents are alive, the will was made and registered. It stated that if any spouse dies, the assets will go to the one that is alive. And I think this question was already answered. Yeah. In case of a single beneficiary and a single child, will has to be probated? Yes, it has to be probated. Can a beneficiary sell the property after or without probating the will? It all depends on the title. Whether somebody is ready to buy the property, because it does not give clear title.
Yes.
If an executor or witness dies before the person who wrote the will, is it necessary to rewrite the will?
Yes. The person is to make a difference. Yes. Then they will have to show that at the time of execution of the will, apart from means both the attesting witnesses expired, then they will have to show that at the time of execution of the will, when two witnesses were present at that point of time, one other person was also present. If he was present at that point of time, at the time of execution of the will, then definitely they can file. Then see, actually probate is to be granted only upon the affidavit of attesting witness, because the person who made a will, he is no more in this world.
Witnesses are not there.
He can make a will. No, suppose if he is then he cannot make a will.
He says if the will is there. Yeah. Okay. The question over here is, if a person, if the witnesses have died, executioners also died. Let us assume a situation. What happens if a will of a person who's still alive, who's made the will, and he's in the 90s and is of unsound mind? Okay.
Because he is unsound mind, he cannot now make a will. If attesting witnesses, both attesting witnesses expired, and at the time of execution, apart from this attesting witness and this person who made a will, no one present, then definitely you cannot file affidavit proving that he was of sound mind and execution happened. Then will is of no use. Then he can make a will. Yes. Settlement is always best in the interest of all people. See, actually, if you can recollect, if a parents bought a toys to their children, both children they are fighting for the toys in presence of parents. So when children are fighting in the presence of parents for toys, then definitely after their demise, definitely they will fight for the property only, because now they are matured, they are interested, and everybody is after money. So I always prefer that gift deed is always better, so that this dispute cannot arise. But at the same time, you will have to be very cautious, because after gifting it out, you have to ensure that they will see you, they will take care of you, otherwise they will throw you out.
And it cannot be reversed. Once gift deed is done once
Yes,
and for all.
you
Now,
cannot reverse.
now one more. If the will is made with two witnesses and the doctor has signed the sign saying the person of sound mind, does it still need to be registered?
Registration is always
It's an option. Whether you registered, not registered, is not compulsory as such.
Compulsory, it
It's
is
up to you. As I earlier mentioned, is one-step protection.
but for weightage purpose we can say that registered will and he was present, he was of sound mind, because for registration 24-hour certificate we annex for the registration to the will. So registration is always advisable, but it's up to you.
It gives a little legitimacy of
Yes,
the
yes.
paper. And all these questions what you have given to us, we'll compile them and answers we'll give them, because everything is video recorded. We'll get the answers in due course of time. Acha, Rajiv, release date. What is release date?
Release means we are releasing our right. Whatever shares we have in the property, we are releasing in favor of gift deeds. The person who is having, suppose if I hold a flat, then I can gift it out. But if my father is having a flat, then definitely I will release my property in favor of my brother or sister.
I'll give an example here. Now, family, father, mother have some property, they are no more. Now there are 5 children. Now, the 4 children will give release deed in favor of one child. So
Yes.
that will go to him. That is called release deed.
Yes,
That has to be registered. There is
Yes.
this registration is also compulsory.
yes,
It is necessary that we should make a will, is not required. If you don't make a will, it will go as per your personal laws, not
Personal,
required.
yes.
But will gives you your intention to whom it should go after you, your hard-earned money. That's it.
yes.
That was asked, the witnesses being having demised, correct? What would happen with us? Because that was an unanswered and a
10, 15
tricky,
years, 10, 15 years.
matter which could happen. So correct. So what he says is that you cannot probate that particular document. Okay, you will have to get a letter of administration after the demise of the person. Okay, so it is.
Yes, yes. But two attesting witnesses are not there to prove the will.
No, after demise only the person after demise.
So the witnesses are basically required to ensure that at least one should be there so that the document of the will was genuine. That is the reason why they are saying. So otherwise it will go in as a letter of administration process where they will treat the will as invalid. So
Give a witness? I mean, does it carry more weightage?
Yes, what you said, registration of will.
No. As a plain will, I write my plain will, and you and one more lawyer become a witness. Does it carry more weightage?
No, not at all. Witnesses can be anyone. Preferably keep younger people that would outlive you.
And
Younger
also
people
trustworthy person who can
and
withstand.
little knowledgeable people. Uh, if a will is only registered but the executor has not yet settled the property on or assets after 10 years, what is the others do?
If executor is not ready to file the probate petition, then the beneficiary can file letters of administration with will annex.
yeah, fine. So this is the flat is unregistered, is registered in Mr. A's name. Mr. A's name. The full name is not mentioned. How are we going to change it to full name? Right? That is registered Mr. A D'Souza.
The flat is
Registered as Mr. A D'Souza. The full name is not mentioned. How can we do that? I want to change it to his full name. Flat is registered in Mr. A D'Souza. Can the full name, and the full name is not mentioned, how do we get this incorporated, the full name? So your question is whether it's Alan D'Souza, Alvin D'Souza, or anything. So you want to know how can that be changed? So this is connected with the society? No, in your original document. Okay.
so. Is it going to affect you?
It can be Alren, it could be Alvin, it could be.
At the time of registration, the Aadhaar card or PAN card must be annexed, no?
Old. He can give an affidavit.
At the most, you can make an affidavit, and as far as this registered document is concerned, then there is one agreement is called rectification deed. In the same deed, one page deed, you can rectify this, but for that builder is to come for the signature. The part. Then indemnity, the person who wants to buy, or whenever you face this difficulty, at that point of time we'll see. By affidavit.
Do it now, no?
Hmm?
You want to sort it out now, not later on.
Then you can file affidavit. You make an affidavit stating that A. D'Souza is full name is so and so, and he is one and the same person. You can annex your Aadhaar card, PAN card.
You have a passport, correct? So you have to give evidential documents to indicate that Mr. A. D'Souza residing in so and so flat, okay, is supported by the following set of documents. So you will have a passport, you will have an Aadhaar in today's time. It does not matter that at one point in time it was registered wrongly as A. D'Souza. It is important for you to do it in your lifetime. That is where your concern is arising. So you can make an affidavit and say that Mr. A. D'Souza.
If it is required, you can give indemnity to the society. That way you can do.
I'll read the question. I think that's better. If an unmarried dies without a will, nomination of the possessions done with the society, what is the status uh, when they wish to sell this property? So we would assume that an unmarried person dies without a will. Yeah, a woman, unmarried woman dies without a property. Okay, and a nomination has been done in the bank. Okay, and society. What is the status, and who will basically inherit that property? I think is the question.
They have to file letters of administration, means legal here. Brother, sister.
Okay, so the question was respect to Christian personal law.
Yes.
Yeah. So gift deed of a property has to be sold by the relatives. Will the gift deed help? Gift deed of a property has to be sold by the relatives. Will the gift deed receive what is receivable? Yeah, but the question is not right. See, the question over here, as written, given over here, is gift deed. If a property has to be sold by the receivables, okay, will the gift deed help? See, if you own a property, you can definitely execute a gift deed in favor of anybody, okay, and then the person who gets that property by the gift deed can obviously sell that property. What if a person dies outside Mumbai uh, while the property is in Mumbai?
Then definitely without will, no?
Without a will.
Then he has to file petition.
Or with the will. So with or without a will.
So letters of administration or probate petition is to be filed in the High Court. Consent.
No, I feel that's a view. In the case of an unmarried uncle whose siblings have passed away and next of kin and are nephews and nieces, can the will be transferring the property to only one nephew be contested? Is the consent of all heirs required to probate the will? So uncle has passed away and his brothers have also passed away.
Can the will transfer property only nephew be contested? Yes, he can contest.
Yeah, so give the answer.
Yes. Other heirs can contest. In case of
Death of a single child, can the assets of the don't have a clear title nomination as the mother is considered without a probate. Okay. Okay. The question over here is, in case of the death of a single child, what are the assets who does not clear the title as the mother has? Okay, in the case of a death of a single child, okay, what is the status of the mother? That's the question. So will she inherit the properties directly without a probate?
no probate or letters of administration is required. If my mother does a will choose property only to
If 2 of the 5 children.
yes.
So the question over here is, if a mother gives in her will mentions that the property will go only to 2 of the 5 children, can it be contested? The answer by the advocate is yes. If the beneficiary has coerced owner and witness to give property to them, can it be challenged? Yes. Yeah, this is done already. Okay, I'm a widower. I'm widowed and die without a will. Who will my assets go to? And if no will is made?
I am widow.
Yeah, I'm widowed. I'm widowed, yeah.
Brother and sister.
So I'll just state the question. I am widowed and die without a will. Who will get my assets? The brother and sister will get.
And if mother is alive,
And if the mother is alive, the mother also has a
first
right.
it will go to mother only. I'm reading the question. If I'm widow and die without a will, who will my assets go to if no will is made? First, if mother is alive, then first it will go to mother only. If mother is not there, then brother and sister will come into picture. No. He's a male.
It's a female.
No, male.
No, but if it is a female.
If it is a female, then husband side relative will come. हाँ.
The man dies and they don't have any children. So he has left behind a widow and he has not put a will. So under the Indian Succession Act, there's, something called his dependents, and they get a share. That is his wife, that is his mother and his brothers and sisters, right? Or unmarried brothers. Just can you give us a little clarification on the Indian Succession Act, which binds us Christians too? What is the Indian Succession Act for Christians?
Indian Succession Act, as per Indian Succession Act, if a male died without a will, then his legal heirs are mother, widow and children. If mother is not there, then children and widow will come. If all of them are not there, then brother and sister will come.
Okay, but if no children are there, then widow and his brothers and sisters?
No, only widow.
Only his
widow. Because there are classes. First class legal heir comes mother, widow and children are coming under class 1 legal heir. Brother and sister are falling under class 2 legal heir. So always first class legal heir will come first. If they are not there, then definitely second class legal heir will come into picture.
And if he has not nominated for his provident fund, etc., and he doesn't have children, then this money, is it entitled? Is his mother and his brothers and sisters also entitled to it?
No, only mother.
Only mother.
Yes.
But there's a case where this lady is a widow and her husband died without a will and without a nomination. And the bank says something about, 30% goes to them and some,
No.
It's being contested. So that's not. Okay, thank you.
Father won't come.
Who is considered legal heirs in case property belongs to parents?
First class legal heir for women, husband and her children will come under class 1 legal heir. As far as male is concerned, then mother, widow and children will come. No. As long as first class legal heirs are there, second class will not come into picture. No way.
Sir, suppose there is a married couple and the husband has illegally left his wife for whatever reason and does not stay with her and stays separately, and he has property and all that, he has a son to that effect, and he marries illegally without the Christian doctrine and has a child to that effect, and he doesn't want to give his first wife anything. How does that take place?
First of all, divorce is not taken place.
No,
right?
no.
Then if divorce is not taken place, then the first marriage is already subsisting, right?
Right.
Then definitely she has a right.
Yeah, so what is the percentage of right? Because he's got another illegal wife where he's born a child, a daughter to that effect. And he promises that he wants to give the daughter the whole 100%. Though he has a son,
Suppose if he gives out the property to the children of second wife, he can do it. But suppose if he made a will, then definitely children of first wife, they can contest the will.
They can contest it, right? Okay, thank you.
Because the marriage is still subsisting.
Exactly.
But sometimes it happens that they separate this fact from the court.
Okay.
So you will have to be cautious.
Cautious in what sense? I didn't get it.
Means suppose if a person died, then
Who-
definitely other side may go to court.
Okay.
So we will have to check whether if someone has filed petition or not.
Hello.
Yes.
Yeah, just want to know if you want to change both the witnesses and the testator, can you do it by way of codicil?
Yes, codicil means we want to amend our earlier will.
Okay.
It's a codicil. If you can take that earlier two witnesses only, that will be suffice.
No, all three can be changed together, testator as well as both the witnesses.
As far as possible, try to have these two sets only. That earlier attesting witness only. That will be better.
I see.
If it is possible.
Any reason why, like?
Sorry?
Why so, like? Why is it better to retain the earlier people? I mean, is there any advantage?
If you can, if minor changes are there, you can make codicil. And suppose if major changes are there, if you want to totally change the beneficiary, executor, then better you should make a new will. In the new will, you incorporate one clause wherein you can mention that earlier will executed on so and so date. That has been, I am revoking that will.
Okay,
that will be better.
Thank you.
You asked for a question as to why the witnesses should be same, correct? Or why it should not be different. Yeah, so you are running into a conflict. Say your first will has two set of witnesses, A and B. You prepare a codicil with a witness C and D. It leaves an open to challenge. The reason is C and D, then there would be either why have you gone with two new witnesses and puts into question whether the first will was done under coercion. So it is in your interest to have A and B continue even if you modify. I think that was your question, correct? You can also revoke the will and then have C and D as witnesses.
Now we have only 15 minutes more to go.
Okay, so there is still some questions at my end. I think let's finish this.
Rajiv, what is the succession part you're asking about? Will and the succession part.
Succession, as far as succession is concerned, first of all, succession is the process through which the immovable property of a deceased person is to be transferred to a living person. As far as succession...
There's a procedure. It's a procedure.
Procedure. Succession certificate is concerned for movable assets. For example, shares, amount lying in the bank, mutual fund. For that we are going for succession certificate. Yes.
There's a question over here. I have nominated my wife and the children in the society. However, my wife has passed away. Only children are survivors. Do I need to give a new nomination or the surviving children are automatically the nominees?
Children are already nominated.
If 50% was nominated, we can give nomination.
But
that will not answer that. Cost will not. Court fee 75,000. Court fee is 75,000. Yeah, fees will not be taking the matter. We are not taking any matter.
so wife is expired. So definitely she's out. She's out. Two children are already
So
nominated.
she's given 50% to the child and children are 25%. Okay. So now in that question, what happens with the children, the nomination that way? Will they supersede and give proportionately 50-50? See, it is 50%.
Requirements of probate.
Just repeat that question first.
Yeah.
They will have to obtain letters of administration with respect to her 50. 50%.
My question is, inherited properties, can you do a 50 some other state?
No. Only your self-acquired only you can give it.
No, agree. But it's in your name only. The inherited properties in your name. Can you do a 50?
Yes, if it's in my name by way of proper transfer, the sections of
That is in some other state.
Huh?
It is in some other state.
Yeah.
Karnataka.
Yes, yes.
You can do it.
Yes, yes.
Can it be contested?
Is the will required for movable
Yes, once
assets
it's,
like shares,
probate is
FDs,
done.
bank
It
balance
can't be contested. It's a final.
when there is a
You have
nomination?
to do a probate of the will.
As far as shares are concerned,
Only,
the shares are transferred after the demise of a person on the basis of nomination. As far as FD and bank balance are concerned, then bank may ask for succession certificate. For that, if you make a will, it's good. Otherwise, even if you don't make a will, but by will you can decide the percentage it should be distributed amongst the legal. Yes, yes.
See, with respect to banks, if your FDs are in either or survivor, it automatically, on the demise of a person, it will pass out. So that is the easiest way to go. With respect to shares, if it is done jointly, okay, if the shares are held jointly also, there is something happens by a transmission of shares, okay, wherein if the first person dies, then you provide a death certificate and the second holder becomes the only holder. Okay.
What is that?
To what level should I include the details of assets in the will? Mutual funds, details of each mutual fund, property details, each property, bank accounts, all bank account details.
As far as possible, minute detail needs to be incorporated in the will. There is to be a clarity that what are the FD details, bank account number and flat number, and how is to be divided amongst the legal heir. It has to be minutely incorporated in the will. That will be better to avoid any dispute amongst legal heirs.
And the solution to this is because you are making a will at a given point in time where your assets may be 50 lakhs, you have 5 FDs of 10 lakhs each. You mentioned the FD number, but after 5 years, maybe after demise, those FD numbers would have changed. How do you handle that? So it is better to state that all FDs, all liquid assets, all immovable assets or mobile assets, because even your property may go into redevelopment and the property contours may change. It was a 2 BHK, now it's a 3 BHK, and you mentioned it as only as 2 BHK. So it's important to document all these possibilities in a will, and that is why it is advisable to go to professionally qualified people.
Rajiv, now what are the requirements of for probating a will?
We require death certificate of the person who left a will, name and address of legal heir, executor's name, and attesting witness name, and property details, and valuation of the property.
Okay.
I think that question on nominations needs a little clarity. I've been just informed. So the question over here was that a person had registered a nomination in the name of his wife and his 2 children in a society. Wife passed away. Does he have to do anything with respect to the change of nominations, or will it automatically flow to the children is the question. Okay, and Carolyn had said that just file a new nomination, which is quite valid. File a new fresh nomination. It is not a very complicated process. Does not involve any cost of money, just a change of forms. So you can then recalibrate that particular nomination on how it is going to proceed in the event of demise. Okay, I hope that is answered. If it is not answered, you can always seek clarity later. The question is, can a gift deed be be challenged, cannot be challenged. So it cannot be challenged. Is it easy to make a gift deed? What documents are required?
For gift deed, we will have to get the gift deed drafted by professional advocate. Then we require a society letter to be annexed to the gift deed that the area of the flat is so and so, building is constructed in the year so and so, how many lifts are there, and this flat is holding in the name of a donor. All these details are required. PAN card, Aadhaar card of the donor and donee is required. Also, BMC assessment, property tax is required, and other documents are required. Apart from that, you need to pay stamp duty and registration charges as per ready reckoner rate. Power of attorney means the person who is giving power to a attorney, to a person, to act on his behalf. In his absence, that person can act on the basis of this power of attorney. But power of attorney, there are two type of power of attorneys: specific power of attorney and general power of attorney. General power of attorney will cover all area. But again, for buying and selling a property, power of attorney needs to be registered. Without registration, you cannot use that power of attorney for buying and selling the property. And simple power of attorney, you can use it but not for buying and selling the property. आता disclaimer there.
Okay, this is the last question for the day. In case there is no will and a person dies without a document, what document is required to prove as legal heirs to the property? As many siblings claim only heir is observed. Okay. In case a will is prepared, and the second question by the same person is, if the will is prepared in the name of only 4 people, and subsequently it is changed to only 2 people, is the first will valid?
We will have to see the will. We will have to see the will. Will is always safe because there cannot be any tampering with the will, addition, alteration. Once will is registered, then definitely it is safe. Yes, sir. Gift deed, you will have to pay for stamp duty and registration charges. Suppose if father is giving gift in favor of his son, then 1% will apply. But if son is giving gift to his, one person is giving gift to his brother, then 3% or 4% may attract. So that will come into lakhs of rupees. Will is better subject to others, legal heirs should not dispute. Yes, registration is not compulsory. Yes, registration is not compulsory for a will. You can write down your will and the same can be probated. Huh. I would like to thank all of you. It's my pleasure to give information I have. And also I would like to tell you that I came here only to give information which I have. It's my pleasure to be with you, and also I am not soliciting any business from you. Thank you.